and adoption is really near and dear to our heart. So we'll finish up the last hour. There's desserts at the coffee bar. So I'll let Damie begin.
All right, thank you so much. I don't know if y'all can hear me or not. How is this? Can you hear us pretty good? I appreciate Rachel and the Young Lawyers Conference for asking me to speak about this. Well, actually, they just asked me to do something, and I love adoptions. That's one of my favorite things to do as a lawyer. And there's only a few things, you know, when you finish the results that you're actually everybody's happy about. Real estate, purchase of real estate, buyer and seller are happy, and adoptions typically the parties are happy. So it's a good thing that lawyers get to do, in my opinion. So we'll go ahead and get started. This is my primary reason why adoption is so important to me. I'm not an expert in this field, all right? I'm just honored to be able to talk to you, and I'm no expert. I looked across the room. I thought young lawyers, these are going to be lawyers that haven't practiced, so if I say something wrong, they're not going to know the difference, but I look around this room, and I'm like, oh no, I saw Carl walk in, I saw you guys walk in, and I'm like, this is going to be tougher than I thought. So, just so you know, I talk about this and I do this because I'm passionate about this. These are my babies, and I got them from Tennessee foster care. So to adopt them, it's just an honor to be their mom. My husband and I couldn't have children, so when God placed these little ones in our home, I was like, I will be an adoption attorney, and that's what I love to do. Is, of course, you can't primarily do adoption, but that is one of the practice fields that I really enjoy. This is John, Ryan, and Emily. We got them when they were 3 and 5, and now they're 7 and 8, and we're just very excited about it. Just one quick little story. I was getting my hair cut, and we tried forever, could not have a child, and my hairdresser said, how would you like to adopt? I'm like, no way. I know. Let's skip it on. She's like, well, their names are John and Emily. Well, John is my husband, and this little dog right here that I had, I named her Emily for reasons unknown. So I had a John and an Emily at home already. And I'm like, maybe I should take a look at this. And so we met little John and Emily and fell in love, and so the process started from there. Okay, we're going to talk about the types of adoptions. There's the parental placement, the agency adoptions, which I consider through DSS. There are other agencies, but DSS is who we primarily deal with when we're talking about adoptions. There's close relative adoptions, step-parent adoptions, adult adoptions. There's interstate and intercountry adoptions, which I'm not going to talk about those two at the bottom. But as you can see, there are a lot of adoptions. So when you get a client walking into your office, you first have to determine what type of adoption am I dealing with right here. There's a lot that goes into that determination. But we did from Tennessee, so we did the interstate adoption, and that calls for the ICPC process, if you're familiar with that. And it just is very involved when you do the last two. We're going to just talk about the basics here with the first two. Okay, the big question is, adoptions are strictly statutory driven. If you've got 63.2, then you're going to know how to do adoptions, but they're very complicated because there's so much that is at the discretion of the judge. And I would love to have a judge up here with me while I was doing this so they can give some insight on their discretionary portions. But it can be very complicated as you try to figure out how to bring it and where to bring it. But this book here, if you do adoptions, how many do adoptions here in your practice? Just a few. This book here, Adoption Procedures and Forms, a Guide for Virginia Lawyers, is published by Virginia CLE. If you're interested in adoptions or if you do adoptions, I would highly recommend this book right here. This breaks down every type of adoption and tells you in each chapter how to do that specific type of adoption. It has forms and a lot of great material in this book. But adoptions, of course, you have the JNDR court and you have the circuit court. The circuit court has exclusive jurisdiction for adoptions. So to file your petition for adoption, you're going to circuit court at that point. But several of the adoptions start in JNDR. You're not calling them adoptions at that point, but you're getting prepared for the adoption in JNDR. Okay, and as you can see, the three types, I'll talk about parental placement adoptions. That's when the birth parents are actually physically placing their child into a home that they may know, just if they knew that somebody wanted to adopt a child or somebody approached them and then they're going to do that. The child's not in DSS care. They're just placing it. The biological parents are placing this child. There's the close relative adoptions, and that is statutory driven. You would have to look in the code, and it's specific. If it is a grandparent, a great-grandparent, an adult nephew or niece, an adult brother or sister, adult aunt or uncle, or adult great-uncle or great-aunt, those are the only people that will be under this close relative adoption. So when they come into your office, you're going to want to find out the relationship between the child and the prospective adoptive parents. There's also the agency adoptions, and again, I'm just going to call this DSS for what we're talking about. But those will all, in some fashion, start in the JNDR court. Not your petitions, but you'll start working with adoptions in the JNDR court. And if you see close relative adoptions there, those are if the child's in the home for less than 3 years, then you're going to start in the JNDR court. For the circuit court, like I said, the petitions will all be in circuit court. But to initially start the adoption process, these would be the adult adoptions. They don't have to go down to the JNDR court. Obviously, the JNDR court doesn't have jurisdiction of the adults. The step-parent adoptions also do not need to start in JNDR court. You can go straight to circuit court. Agency adoptions, I put agency adoptions on here because that is where you're actually going to file your petitions, but you're going to do some JNDR work first. And the close relative, if the child's in the adoptive home for 3 or more years, then you can go straight to circuit court. The reason why you might do this, you do have some options here. You're not going to get a GAL in circuit court unless the adoptive parents are going to pay for that attorney. You may want a GAL for some reason, so if there's discretion in the code, then you may want to start in JNDR court with consents and different things in order for them to appoint, the court to appoint the GAL who could follow the case up. So there's different reasons to choose, but you also are going to save your clients money if you can find a way to start it in the circuit court, because there's going to be a lot of time in JNDR court and a lot of time in circuit court. So if you can get to circuit court first, do that if money is an option or money is an issue for your clients. Okay. And let's see. All right, the pleadings, when you start in circuit court, of course, every adoption is going to start with that petition for adoption. Okay? And this includes exhibits. Your petition, you could have a birth certificate, you could have the consents if you started in the JNDR court. This is the termination of parental rights may have already been done. And so anything that is done in the JNDR court that pertains to this adoption, you're going to want to have those orders as exhibits in your petition going up to the circuit court. And you also must have the request to change the child's name. Has to be inside that petition. You have to request it at that point in time. So it's very important that you talk with your clients, who would be the adoptive parents, to find out if they're going to rename their child and what the name is going to be, to make sure that you put that in your petition. And you do not include the birth name of the child unless the child's name is not going to change. And lastly, the difference in this pleading is one of the very few, and I really don't know the rationale to it, but this petition must be signed before a notary public by the petitioners. Does anybody have any insight into why that might be so? It's like the only time that your signature alone is not enough. I don't know if they think we're going to fraud the system by getting these kids adopted, but the adoptive parents must sign that petition before a notary public, and you as well. Oh, Okay, here lies the biggest confusion about adoptions. One of the biggest confusions about adoption is you have an order of reference. That is also a pleading, okay, that you may or may not have to have. There is an interlocutory order, which you may or may not have to have. It's very complicated, and most of the time it says discretionary according to what the judge wants to do. So it's kind of hard sometimes to prepare prior to talking with that judge, but some are very clear on what you would need. But looking at the order of reference, that you can see the statutory codes, and like I say, everything. If you have 63.2, read it when you do an adoption. But you'll also see the term investigation and report. That will be in the code. You won't see order of reference very often, but investigation and report, whenever you see that term, the statute is talking about that order of reference, which is actually a document that you're going to create to submit to the court. And what that does is it asks DSS to perform and submit a report to the court within 60 days. And this is going to be just to find out, like most of the time these are used in agency adoptions, and we'll get to some charts, because what I'm saying up here is going to be just like mumbo jumbo if you don't deal with adoptions a lot. It can be kind of boring. But this is a time when DSS is going to make a report and actually submit that in writing to the circuit court, stating that the people are financially and morally able to adopt this child, that they do recommend that adoption be okay. It's different than a homesteading, and it's different than what they have to do in an interlocutory order. Most of the time, this is waiting on DSS to get what is called an adoptive number, an adoption number. It takes a long time. They have to write to Richmond and get it, and the people are waiting for this report to get sent to the court. Most of the time, it doesn't take 60 days to get, so that's the good news. And there are the statutory requirements for the report, what DSS has to put into that report as an order of reference. And the interlocutory order, and you'll see the code section there, this would be called the probationary period. This is typically done, this is at the discretion of the court, but it is typically done in parental adoptions. The reason is because perhaps the adoptive parents don't really know who that person is, the biological parents don't really know who the person is that's adopting the child, as far as a lot of the stuff that would go into this, like their finances or their home environment, different things like that. So this is, and the child is likely not in that adoptive home for very long. And so the probationary period, I wrote on here DSS to perform visitations with a report to the court no sooner than 6 months. It is a typical 6-month period. But if you get real technical, and there's really not a lot of case law on all these things, this is very statutory driven. So if you read the statute, the requirements include DSS must complete 3 visits within 6 months, no less than 90 days between the first visit and the last visit. So theoretically, in 4 months, DSS could have gone to that adoptive home and seen that child, and it be 4 months because the 90-day period. Does that make sense, what I'm talking about? But I have not seen it, and maybe you guys have, a probationary period be less than 6 months. So that's something that they'll have to do. You'll have to explain to the adoptive parents that regardless, you're going to be waiting 6 months before we can even turn in a final order. Y'all have any questions about this? I just kind of dry stuff, but and I am no Chuck Slim. I am not good at all this. You also have the final order. Okay, this is submitted after the investigation and report. Remember, that's the order of reference provided by DSS, and it's submitted after a probationary period. Some folks, decide to go ahead and submit that in to the court, and it's in the file, and that's fine. I just choose to do it after I get that because I can tickle it and keep it on my calendar, and that's going to get me to do some action. I know I want to keep up with that case because I know I have to do that final order. It is also submitted with a petition for the step-parent, the adult, and the close relative of 3 or more years of the child in the home. So you can go ahead and submit the petition and the final order all together on those 3 cases. One of the reasons is because the court really doesn't have anything to decide on these. And everything I'm saying, remember, is at the discretion of the court. So you could be blindsided. But if everything is in your petition, there's really nothing for the court to question. Then submitting that final order, they may just go ahead and enter that order for you, and you get your adoption very quickly that way, instead of them calling and saying, where is your order, because there's nothing for the judge to do. Go ahead and submit that. Okay, this, oh gosh, I feel so bad for you guys out there listening to this, because this is where I'm going to get into, Donnie Williams is the one to blame on this one. We were talking about a flow chart, and this truly is a good way to determine where and what you're going to do when an adoption walks in the door. Remember the parental placement. This is, to me, the most complicated adoption to do. You can have parental placements when the expected mom wants to go ahead and adopt her child out prior to birth. She can't prior to birth, but she can go ahead and connect who is going to adopt her child if she wants. Or this could be the baby's already born and she doesn't want to keep it, and she's found some people that will adopt the child. So remember, you're going to start in the JNDR court with this one because you have to deal with consents. This is something that is in the code, but we practice it. So the JNDR court should order DSS to do an adoptive home study, and that happens. An adoptive home study, the order has to say adoptive home study in order for DSS to understand it's not the regular home study. If you deal with JNDR cases in any other way in custody, and you do a home study on each person's home, it's a different home study, because statutorily they're going to be asking things about, are you morally, financially capable of training and growing up this child? There's a lot of different things that they're going to be looking at. They also have to ask the the birth parents questions that have to be in that. So the adoptive home study is completely different. But the code says that before the consent hearing can be done, the adoptive home study must be ordered and completed. What we typically, it just seems as if they order the adoptive home study and we're dealing with consent right away. But that home study has to be back in order for the judge then to have the consent hearing. And the consent hearing can't be before the child is 3 days old. Okay, so you can start on the home study, but you cannot have a consent hearing before that child turns 3 days old. All right, and that one has to be in court. Your consent hearing must be in court for parental placements. Okay, and once the court has determined the adoptive home study is good, it's recommended that these parents adopt this child, and the consents have been done. We're going to talk about consents a lot more because that's a notice of consent are very important in these types of cases. Then, once that's all completed, then you're ready to go to circuit court. Okay, and there's where you're going to file, as you can see there, your petition. This is going to require the interlocutory order. You are going to have to do an interlocutory order at that point. So go ahead and file your petition with the interlocutory order, asking the court to give the 6-month period where DSS is going to go do a thorough investigation. And then you'll, of course, after that's completed, submit your final order and a VS-21. Every adoption with the final order, you need to do it a VS-21. You can get that online. That is the report of adoption to Richmond, to the vital statistics. It doesn't matter if the child's born in Kentucky or Tennessee. We have to do here in Virginia the VS-21 report of adoption, which you fill out just like a birth certificate application almost. But there's a point at the bottom where the court is going to certify that the final order is completed. And that will go to Richmond. And if it's a Virginia adoption, then they will work on the birth certificate, or a Virginia-born child. But if the child is born in Tennessee or Kentucky or anywhere else, then Richmond is going to send this report of adoption to that state where that child is. And then the birth parents are going to have to go to that state to get the new birth certificate. Does that make sense? Okay. Any questions about how you maneuver around in the parental placement, at least pleading-wise, and how you start? close relative adoption, and this is if the child's in the home for 3 years or less. Yeah, you're going to start that in J&DR court. I feel like this is mind-numbing to you guys, and I'm so sorry. I can't make this exciting, you know. But the close relative adoption, 3 years or less, you're going to start in the J&DR court. And that is where, again, you're going to have to do the adoptive home study, ordered and completed. The consent hearing, this does not have to be in court at this point. You can have consents outside of court. And when I talk about in court or out of court, what I'm talking about is the biological parents do not have to be in court to execute the consent. You as an attorney can draft the consent order, and you have to make sure you have all the statutory requirements of the consent. It has to be voluntarily, no coercion. There's a whole laundry list. They have to know about the revocation of a consent, which is 7 days, how to revoke their consent. Your consents need to be very thorough. If you're in question about how to do a consent, J&DR court has a form. Just get that form. You can get it online at our Virginia forms or at the Virginia Supreme Court and get the form. And then just make your consent form follow that form that the court can use in court. Okay, just make it say the same thing as that. So those consents can be executed outside of court, and then you take those consents and add them to just as exhibits for the court for the consent. But once again, adoptive home studies and consent is finished in J&DR, then you're going to go to circuit court again, exclusive jurisdiction for adoption. File your petition, and here's where you can file perhaps your final order. Here's where you may have a court saying, well, I want to order a reference. The adoptive home study should, if you've attached it and sent it up to circuit court, should take the place of any investigation that the court needs. That should have everything in that the judge needs to see. The DSS has already completed everything. So you shouldn't have to have an order of reference or anything like that, but be leery that the court may say, hey, I want an order of reference, turn it in. I want DSS to go out and talk to some more people. You shouldn't, but it's still at the discretion of the court. And of course, you're going to do your VS-21, report of adoption. Okay, and here's a close relative, 3 or more years. You're going to start in circuit court on this one. And this is a good practice tip. When you have someone come in who, say, is a grandparent, and this child's been in their home for, say, 2 years and 6 months, you really need to be able to explain to them the difference in the less than 3 years in the home or more than 3 years in the home. Because at this point, it's going to take you likely 6 months if you start in J&DR court with less than 3 months. You finish all you need to do down there, and then you finally get this up in circuit court, and if the court says I need an order of reference, then it's just taking a very long time. It could take you longer to get this child adopted than if you said you may want to consider waiting 6 months till that child is in your home before you file, because then we can go straight to circuit court. And a lot that goes in that, because you got to deal with the consents of the parents, the biological parents. So there's a lot of, you really have to know that A causes B causes C when you're trying to determine how to advise your clients at this stage, depending how close they are to that 3-year mark. Yeah, the adult adoptions, those go straight to circuit court. You file your petition and your final order and your VS-21. Now, adult adoptions, those are people that are 18 years or older that somebody is trying to adopt. That may sound odd. Has anybody done adult adoptions? Yeah. And I tell you, I've only done one. I don't find them to be very, they don't walk in the door every day. But my scenario was where the stepfather had been the stepfather for many years, and the girls in this instance, they were, 19 and 20, they were in college, but one was about to get married, and she wanted that maiden name to be the stepfather of who's basically raised her. So that was one reason. Anybody have any other reason why an adult would be adopted? Did you?
Well, I just had read that the biological father wouldn't consent, and you really couldn't have done it when they were a minor. But then the once they became an adult, then they wanted to go ahead and do it because that person really was their father.
Right.
They didn't want to go through with the hearing when they were a minor. But the
Well-
mother did, just because, you know, that's hard to do anyway. And so it wasn't that the guy was a horrible guy, but just one of those that didn't have much involvement.
Yeah, that's an excellent point too. I mean, and all these things you have to think about when they walk into your office. I never thought about that. But if you get somebody who is 17, then you may want to think about that. That's a very good point.
Could be somebody with a disability.
Yeah, absolutely. Somebody with a disability.
Had a foster mother and a foster child, been there with him when she was 15, and then at 28 or 29, lived there that long. They adopted.
Exactly. Being, you know, in that, well, we can't call it permanent foster care anymore, but exactly. That's a very good point. I was going to see if I had something in here. The code section is very clear on some rules for adult adoptions. Like you cannot be closer than 15 years from the adoptee and the adoptive parent. Does that make sense? So you can't be within the 15-year period. And in that adult adoption, you know, there's no consent except for the adult being adopted. You know, the parents are out of it at that point, and it's just the adult who has to sign that consent to be adopted. Okay, and the agency placement, and this is actually, and as I say, I'm going to use this through the DSS system, and you know, typically those are foster care type situations. So it actually is going on in JNDR court. You're not even thinking about adoption probably at this point, but you have typically findings of abuse and neglect. So you know they have that 12-month period for the parent to get their act together and do everything they're supposed to so the child can be returned home. But when the child's not, then you know, the consents can be either the entrustment agreement, where the parent says, I'm not going to fight this anymore, I'm going to go ahead and let my child be adopted, and I'm going to go ahead and give up my rights, a voluntary termination of parental rights at that point. Or it could go where DSS has to put on the full case of the whole 12 months about why the parent is not capable of keeping their child. And then it goes to an involuntary termination of parental rights. So either way, your consent at that point is, you know, twofold. It can be very quick, or it can take a very, very long time. And then you have to remember you have the appeal at the end of that. That goes to circuit court just on the TPR, and it can take a very long time this way. But the JNDR court does not, once that termination of parental rights is completed, the JNDR court does not get rid of the case at that point. They have to continue to monitor this child. So for every 6 months, the child will be back on the docket just to find out has this child been adopted or not. So the JNDR court case doesn't go away until you get that final order back to the court or a report to the court stating that that child has been adopted. So that's going to stay on your docket too, at least while the adoption is going. So, but once that's all completed, the consents and everything are done, appeals, you go to circuit court with your petition. A lot of times when DSS does this, some DSSs have a rotating list. Parents, adopted parents can also request their attorney. You can work with DSS as the attorney, and DSS is actually paying you the adoption fee to do this, and it's capped. I don't think it's 1,000. Somebody said 2,000, but 1,000 is what I understand it to be. But there, you're going to see this more than likely for the very first time. If you're a GAL in that lower case, then you can't be the attorney to send the adoption. Because if there's something wrong and they need the GAL for something, well, you're now representing the adopted parent and you were representing that child, and obviously we can't represent both parties in the proceedings. So just be mindful of that. You would file the petition, and you go ahead and submit the order of reference at that time, because everything has been done with DSS, home studies, visits. I mean, they've been visiting with this child for 12 months now, basically. So all you need is the order of reference sent up. They're going to confirm that in a report to the court, and it's just going to go smoothly from there. You just submit your final order and your BS-21. Any questions on the agency placements? Okay, step-parent adoptions go straight to circuit court. The petition will have both parents on there, the step-parent and the biological parent. the biological parent has to be the petitioner in order to show consent of adopting this child. Of course, you're going to be dealing with consent of the other parent, but the petitioners must be the step parent and the biological parent, the spouse of whoever's going to adopt that child. Both have to be a party to it. But you're going to do that petition. You're going to submit a final order and a BS-21. These, again, at the discretion of the judge, they may call you in to have a hearing. You may want to go ahead and set it on the docket to have a hearing, to go over the petition. Just know either way. I always put these on the docket just so the judge can swear them in, and we'll talk about that kind of at the end, because the final order should come at that moment. And if the step parent is adopting because the biological parent is deceased, then your death certificate must be an exhibit to that. But there's no notice or anything, obviously, to give. And some of the questions come up, well, what about the parent of the deceased? That's a tough one. But, they have no rights to stopping the adoption. So that's a tough one. That's a tough one. Not as far as practitioners go in the adoption, but just emotional stuff that might be happening. Consent is, this is the hard part. This is about the hardest part of the adoptions, can be, the consent. When you have, of course, we talked about the agency placement already, and that's the entrustment and the involuntary TPR. Those are the easiest, cleanest to get. The parental placements, this one I want you to really listen to, because this one is so statutory driven, and it depends on which judge you get as whether they're going to read every single word of that code, or whether they're going to let the letter of the law versus the spirit of the law rule. One parent must be present at the consent hearing. And remember, the consent hearing is in JNDR court. So one of the two have to be present according to the code. And the consent must be, I put this in quotes, executed before the court. Like that signature of that one person must be signed on that day in front of the judge. And the child must be at least 3 days old. I thought, I guess I didn't pay attention to this, but it's a horror story. When you do adoptions, you're just so excited to get this thing going. And we go through JNDR court. We had a parent there in JNDR court. His consent, the father doesn't have to be. What the code says is the mother shall be present for the consent. But then it drops down a couple lines and it says, but if the mother is not present, then the father shall be present. So this time the mother didn't respond to notice or anything. You send out though prior to your court date, because you have to get both parents' consent. But you only need one parent in court. So you need to send out both consents, because you don't know who's going to show up that day in court, right? So both consents were out. The father signs it, mother signs it, sends it in, never appears. The father does appear. And the judge goes over every single line of the consent. He uses his own order, asks the questions again. He accepts the consent. He gets the order of consent. He signs it on that day that this person was here and that he had gone over everything. We go up to circuit court, and the circuit court said, even though the father was present, and even though the judge went over every single line of consent, and he signed it on the date of the consent order, the father signed it 2 days earlier, that consent form. I was blown away, because she said the judge said, the letter of the law was not met by the term executed in front of the court. I just assumed when the judge is going through that consent order, his own consent order, he signed stating that consent was given on that day, that it was, he accepted that consent, that would be enough. So talk about heartbreak. You go all the way up to circuit court, and now you got to backtrack all the way back down. The father happened to be homeless. Just like, praise the Lord, they found him to be able to get him there. It was a big ordeal. So parental placements, like I say, are very tricky. When you get one of these, please look at the letter of the law. That's so important. Make sure there is a parent in court who actually signs. Go ahead and get their consents because you don't know who's going to show up for that day, but make them sign a consent in court on the day of the consent hearing. And a step parent, again, biological parent must be a party planner to it to acknowledge consent. Now, the other biological parent can execute outside of court. You can go ahead and mail them the execution or the consent form, and they can sign it for notary public and then send it back to you, and you can have that as an attachment to your pleading. So that's no problem with that. Okay. The adult adoption, the adult is the one who executes the written consent. And it can also be outside of court. You can go ahead and get them to sign that when they sign, when the adoptive parents sign the petition. Go ahead and have that adult there too. Have them sign off on the consent and have that as an exhibit for your petition. I'm probably going to be quicker than the hour. There are other consent issues. If the child to be adopted is 14 years old, then that child has to also consent to the adoption. And you have to have a written consent form for that child, and the child signs off in front of a notary public saying that they're okay to be adopted by this person or these people. All right, that will be a part of your petition as well. Now, there is no consent required if the contact or visitation by the biological parents, if there is no contact or visitation by biological parents within a 6-month period immediately prior to the filing of the petition for adoption. You must always remember that, because if people come to you and ask about adoptions, but the parents are not consenting, or they've talked to them and they don't want to do it, but they haven't seen their child in however long, 4 or 5 months, well, you want to wait. Do not file that petition. You want to hit that 6-month mark with having no contact and no visitation. If you do it at the 5-month mark, you're going to have to get consent of these parents, and now you're in an awful mess trying to get consents from them. So you have to be mindful of that 6-month mark. But Copeland v. Todd, which I think the full site is in your materials there, this would be heartbreaking. This child was in this person's home for years, and the adoptive parents wanted to adopt this child. They reached out to the mother. She had not seen this child, gosh, I guess 2 or 3 years. Nothing. Maybe once in a while would call and talk to the adoptive parents, but would never call and talk to that child or ask to even see that child. But when the adoptive parent asked her to allow them to adopt the child, she's like, well, let me see, can I just see the child? And they were going to go take the consent, and they brought the child to that consent signing. And that person spent 30 minutes with that child, and that cut off the 6-month period. That is a shame. Years not seeing this child. And just by them bringing the child, she asked, and they said yes. The judge said, sorry, even though it was a brief encounter, that chopped off that 6-month contact. So be very, very mindful of that 6-month period, okay? Now, you can't tell your clients, oh, just don't tell them you can't visit. It's for good reason, or for no fault of their own, or no fault of yours, you know what I mean? You're not blocking it all the time. Some other issues to think about. If the biological parent does not consent, then you have to have a hearing, and the legal bar there is the consent being withheld contrary to the best interest of the child. So there are factors here that you'll see in the code that the court must go by in order to determine if consent is being withheld to the best interest of the child. And make sure those that the judge actually voices those. If you can get them in an order, if you're writing up an order, get in that code. Okay, so you can prove that those factors were actually used in determining. And it's not determining whether this child will be better off in the adoptive home. Well, 9 times out of 10, the child will be better off in the adoptive home because something has happened. It's got to be more than that. It's got to be, they've taken away the term, it would be detrimental to the child to go back to the other home. But the code has made it in such a way that that is actually the 2-part prong. It's not just, is it going to be better over here? It's just not going to be good for the child to go back to the adoptive home. So you will have a trial if there is no consent signed, and then you're going to have to bring up all the reasons why. Look at those factors and have your evidence line up with the factors. If there is no, this is very interesting too. I don't know. I've never had this happen, but if this does happen in your case, which is highly likely, just remember this code section. If the non-consenting, if they're not consenting, and they fail to appear after proper notice, then they waive any objection or their right to consent for any hearing that is properly before the court. That's huge right there. If they don't show up to the hearing after being properly served, and it's not one that you've continued, and now we don't really know if they had notice of this, but if they're properly noticed and they fail to appear, then they waive the right to consent at that point. The judge could go ahead and enter that order. But that's a good code section to know, or to at least argue. And of course, the court is going to determine, if you can use that or not. No consent is required of a biological father if the mother executes an affidavit stating that the biological father is not reasonably ascertainable, and there's no evidence to refute the affidavit. So she could just say, I have no idea, and get that in, and if nobody comes up and says anything different, well then you don't have to worry about the biological father at that point. Okay, and who is the father anyway? Fathers are very difficult. We know the mother. Mother's quite easy. And as you guys know, there are different types of fathers out there. Loaded there. But this is actually in the code. So if you're wondering how do you define each of these fathers, the court throws them around, like everything. But if you need to know which kind of father you're dealing with, there's acknowledged, you'll see the code section there, that's both mother and father have signed a voluntary statement confirming that he is the father. Both of them have to sign that, say, yes, I am the father. And you have the adjudicated, that's where the court has established paternity through a paternity test, and then you have a court order that states he is the father. You have the presumed, so the man and the woman are married, and a child is born during that marriage. The man and the woman are married, they could be separated or divorced, but this child is born within 300 days of the event, their divorce or their separation. And the code section is there, so he would be presumed. And then putative, which, if anybody has any questions about this, I'm not going to answer. Putative, this is if a man has registered with the putative father registry. It's the craziest thing. If there is a moray somewhere in Virginia, in Tennessee, in Kentucky, wherever, and this guy wants to say, I had this relation with this woman here, then they can go and sign up to say, yes, if any birth comes out of this union, I'm the man. Come get me for child support and for everything else. So, I don't know why people would do this. If anybody has any examples of why someone would go and register for this, you can let us know, but if there is a putative person, if she says it is Joe Blow, but she doesn't know where his address is, and we were together in Tennessee, you have to write, DSS has forms to check in Virginia, you have to get online and get, and fill out. DSS will send it into the registry, and the registry will send you back something that says there's nobody by that name, or we can't ascertain anybody in this database who matches what you just told us. That will have to be an exhibit in your petition as well, okay? And you have to do it in every state that there possibly could have been, a child. Maybe. So that's just make sure, that you look at that. And people actually get notice, 2-day notice that you're going to register. There's a whole lot to it. Just remember that's out there. It is code driven. So if you run into that problem, just get into the code book. All right, practice tips. So we only have 15 minutes. I know you guys are so happy about that. A single petition, this was very odd to me, but a single petition can contain more than one adopted child if 2 or more children have the same birth parents. So you can put 2 kids, and why this might be good and appealing to your client is because it's $85, $80, whatever it is to file each petition. So you're going to save money to do that. So they can do that, but I'll tell you that practically it's not the best idea. Saving that money in the long run, I don't think the adoptive parents will be very happy, because if you have one child that has medical needs, or they're in 2 different schools or whatever, you're going to take that one order for both of your children, and now you're giving them, information about your other child as well that you may not want to do. Or when they grow up and they need that, they're going to be attached, in that pleading, where that final order could just be directed toward them. That final order, just to have that one child's name, and so they can divide it up without having to carry around their brother or sister's name on the petition. So it's a good idea to separate them out. The birth parent under the age of 18 has the legal capacity to sign a consent to adoption and perform all acts as if they've attained the age of 18. I think that's contrary to what we're thinking, but the code says that very clearly, as in, does that mean they don't need a GAL, as an incapacitated person? Because that's exactly what it's saying. They are not incapacitated, that they're as if they are 18. So, and you should also, this one here, the intake, if you do adoptions, you really need a very good intake form, because it's so embarrassing to go back and ask them along this long journey every single question that you need for each pleading and for each document that you're going to be submitting. Make sure you have an adoption intake form in your office. Go through the pleadings and go through, like in your mind, how are you going to determine what type of adoption this is? So you're going to need, questions about your relationship to the child. How long has the child been living in your home? All these things to determine which type of adoption you're going to use. And you also need this information when you do your pleading later. You're going to need to know, are you going to change the name of this child? To what? You need birth dates. You need to where the child was born. And there are forms that you're going to need. VS-21, have that with you when you're doing your intake form. Go ahead and get that stuff. You're going to have questions on the VS-21 that says, what is the adoptive father's usual occupation? So go ahead and write down, what is your usual occupation and what field is that? It's so crazy, but that is a part of it. What is your educational level? It's going to ask you those things. Go ahead and get everything you need from the VS-21 and your petition in your intake form, so you have it and you don't have to go back to them a lot of times asking these questions. And if they don't answer it, that's fine, you'll ask them later, but just have it. All right, and this is important, and it's important to me because these last parts I'm coming at you from a lawyer, but as an adoptive parent as well. You can ask your clients, do they want the judge just to enter that final order in their chambers? And you can also ask them, do they want like a ceremonial type entry of that order? If there's a babies, maybe not so much. But if you've got a teenager or something, or you've gone through a lot together, or you've got a lot of family or church, or a lot of people that want to experience this, ask them up front, because you will need a notice, or you will need a hearing date from the court, and you need to tell the judge, we want to do a ceremonial signing of this. Can people bring in cameras and all this stuff, because they're going to want to do that. Bird, I had one with Bird, a ceremonial like this, and he actually allowed the boy, he was I think 11 or 12, to come up on the bench, and I made a place for his name along with the parents, and the little boy got to sit in the judge's chair and sign his name to his own adoption paper. I mean, it was beautiful. The sheriff came up, gave him a hat, and he bailiffed for it. It was a big ordeal. He was very gracious in saying, anywhere you want to go take pictures, just move around the courtroom. And it was great. So, you may want to ask those kinds of questions to see how a parent feels. It could be a very great day. I also, let them know, hey, you can sign it quickly, probably more quickly, by getting the judge to sign it, and then you go and you have your own family big function. There's all sorts of ways to celebrate an adoption. But that is one I'll never forget. It was a great day and a great experience for that little boy. And as you say, important event for parents. Important. All right, customer service. This is what I want to get down to, and it touches on some of the stuff that Chuck was talking about. When your final order is entered, remember at this point in time, this is like one of the most important times for adoptive parents when you're getting ready and this final order is done. be sure that they receive at least 3 attested copies. And if you've not experienced adoption afterwards, you realize you're going to need all these attested copies because everybody and their brother needs one attested. So go ahead and ask the clerk to give you 3 attested copies and explain to your client how they can go get more if 3 is not enough. Also send a closing letter with good instructions. And if you don't know how an adoption ends after the final order is over, like we close our books, right? But for them, it's just beginning. So they're going to need to know, how do I get a new birth certificate? If you're not going to follow through with that process with them, you can print off forms for each state on how to do that. Virginia's easy because you've already done it with the VS-21. There is, well, we'll get down to the bottom part there. So do some research on your own. Like if they're a Tennessee-born child, get to the vital statistics in Tennessee. There'll be a form there. You can print it out and give a copy to that parent. That's just an extra customer service situation. How they're going to have to get a new Social Security card. You know, how do you do that? And honestly, that just takes the certified attested final order with a Social Security, I think it's SSA-5, that you can print off just the application for a security card and tell them to go down to the Social Security office and get that. But being able to conclude or to tell them how to get these things is going to be very important. They're going to feel very dropped once the final order is done, 9 times out of 10. Medicaid card, if that's applicable. Also remind them they're going to have to take these orders to the schools and to the doctors. I mean, everything about this child's life has just changed, and it's all generated by this order that everyone's going to want to get their hands on. And also, be excited about this part. You know, you may not have that emotion tied to it, but trust me, this is no different than if you guys have kids and y'all had kids naturally. You are waiting that last month, you're like, oh, it could be any day. You've got bags packed, you know, you are so excited, it could be any time. The adoptive parent is the same. We have the children in our home, and we consider them ours, basically, but it's that piece of paper that you cannot wait to get, because that seals the deal. I mean, you know, you're wanting to know, where is it? How long is it going to take? I mean, you cannot wait. You're as if you got your bags packed ready to go to the hospital. You just want that order. So ADSS can like leave your home for good. You know, you don't have to have people coming in, investigating you and different things. But those kids have your name at that point, and it's so vital. So don't procrastinate on adoptions, please don't. It's so important to the parents. Let's see, find out by calling, going online. Okay, we talked about that, how to get your other states' birth certificates. Now, if you have a Virginia child born in Virginia, you need to go ahead and collect $10 payable to the vital statistics. You have to submit that $10 with the VS-21. You are going to cause tons of delay without that one little check. That's the administrative fee if your child's born in Virginia in order to get them to make the new adoption, the new birth certificate. You need to go ahead and submit that $10. Just go ahead and tell them when you're filling out that VS-21, tell the adoptive parents to give you a check, or if you're going to do it first and then they'll reimburse you, but don't forget it. It's in the instructions. It's $12 per birth certificate. They're going to want to get more than one, you know, get 3 or 4 birth certificates at that time. Don't forget that. That will delay. And here, I just wanted to show you why this is so passionate to me. You know, this is the end of this presentation, but just as I said, that final order, it may be the end of the file in your office, but for me and for everybody who's adopted, it's actually the beginning of the rest of your life and of their life. So that's my beginning. So just remember, these adoptions are so vitally important to the other person on the other side. All right. Thank you guys so much for listening.
I had a question.
Oh no, Roger.
Do you know of any way to undo an adoption?
Oh my. I'd have to think about that.
Greg and I've got a case on that.
I mean, I think if it's after 6 months, you,
No,
so it's unassailable then.
oh, this has
In
been
the
long.
6 months, you
This
might.
kid maybe, this kid's 16 years old. It's been a while.
I don't know. I can't imagine, unless you could find somebody else to adopt him.
Yeah.
Any other questions? All right, thank y'all so much.
Almost, so we don't have to-